welcome to the Global Resolve Mission Mediation. It's a talk show where we invite thought leaders and influencers who share with us their perspective and thoughts on the subject of mediation. And today we have Dr. Karnika Seth. She's a cyber lawyer based out of NCR, and she's very active in arbitration and the mediation space. So welcome, Dr. Karnika Seth.
Thank you, Sanjeev. It's my pleasure and privilege to be here with you. And I'm looking forward to our discussion today on mediation.
Great. So let's start with your initial thoughts on the topic of mediation, how you've seen it evolving, and what is the future you see about mediation in the Indian context?
Well, mediation is something that we are really looking forward to because knowing that ADR is a conflict resolution mechanism which is very fast paced and one can actually achieve a lot in the smallest time frame, and it's something that most litigants they would be actually ready to explore this as an option before they embark on this litigation as a means of resolution of their disputes, or getting justice rather, I would say, because there are different connotations to this, but by and large, looking at the current scenario globally also, where in the US, for instance, 80-90% success rates in mediation have been projected. In India also, we've seen a huge success of mediation so far. Specifically, during the pandemic, we found a lot of, surge towards mediation rather than litigation as an option to litigants. And it is something that one would, really evaluate the success rate, then definitely is something that goes far more promising, than even arbitration, I would say, because having practiced this field, even arbitration or litigation, we know the ins and outs of it, and we understand the kind of time which is consumed, in both the processes. Though arbitration initially was, introduced for the reason that one has a lot of backlog in courts at the moment, and has been since quite a few years. We try to reduce that through introduction of arbitration. However, we have seen a current trend change towards mediation because of the huge complexities of arbitration as a mechanism in itself, and the prolonged number of hearings and the further challenges to award, which makes it a very circuitous issue rather than clear cut resolution of disputes. The shift has also been in the mindset of the litigants towards even going with court annexed mediations. However, I'm focusing more on pre-litigation mediation here. The focus here is more towards that, because mediation in itself is a full, I would say, great solution and a full bodied solution, something that one doesn't need to then resort to even other means like arbitration or other hybrid mechanisms. Unless one really needs to, and there is a deadlock, or there's something which we can't proceed. There are also plus points there, because MedArb is another, hybrid model which is being encouraged. So in case mediation doesn't lead to any good solutions, then one can actually go in for the hybrid versions of, the same. Negotiation is normally the first stage what a litigant really goes through. And if it doesn't succeed, they go into mediation and then, explore even other models before actually resorting to litigation. So that's something I see a very promising trend. And I was reading, about NASA. I was very happy to see that they have resolved more than 70,000 cases in India in mediation. And that's a very good figure to go with,
Sure. Absolutely. So you made a mention of pre-litigation mediation, right? Which is akin to an extent a private mediation, because even before the parties have to reach the court, that's what they should try ideally. And I hope that mediation bill, as we currently see the parliament is discussing, probably would do its bit. But if I may ask you, would you see a parallel between a court annexed mediation versus a private mediation? I mean, what are your thoughts on this particular differentiation, which continues to be a concern for a particular section of society, because
Yes.
there is no party autonomy, or it's a kind of a diktat as in court annexed mediation, and the environment probably continues to be a bit different. So your thoughts on
Well, as per our section 89 of our CPC, we have been encouraging a lot of ADR processes in India, and mediation being one of the principal ones, in the conflict resolution domain. However, the kind of mediation which comes about, I mean, the characteristics may be very, very, clear. That's the basis of having any kind of mediation, whether it is court annexed or otherwise, even in prelim. That the voluntary part of it, if it's a voluntary, if parties are willing to explore a mediation, then even before they lodge a litigation, that's something out of consensus. They both want to do it, and they consent to it, and they go ahead with it. So it's more voluntary in nature. In terms of the mediation bill, now whether this will remain voluntary or not, because they have to, before filing any litigation, go through a process of mediation by virtue of a statute. So that's something we were. It's a point of debate whether this remains voluntary in the first place, because the consent has to be out of your own free will, than any statute can dictate the same. So that's a point of contention. And also when it comes to court mediated I would say cases where the court annexed mediations take place, we have frequently seen in the courts of law, again, courts encouraging the same. However, when it comes to those kind of cases, more often, if the cases are resolved through the same, it definitely does save cost, time, money, and a lot of time of the court. That is the main thing, and it gets to a solution which is maybe favorable to both, and that's why they consent to it. But it's more like a settlement, and it passes like a consent decree. So there. And even in arbitration, for that matter, arbitration section 74, if you look at that, those are also settlement orders, but then they're more like arbitral awards. So it doesn't really go in the same length or in the same legal implication as a binding settlement agreement, like in a contract, as a contract. So there is a difference. There it is court annexed mediation, so it's a consent decree. It will be taken like that. And here, in the case of pre-litigation mediation, it's completely a settlement between two parties, which is a binding agreement between the two, which can be enforced in a court of law.
Got it. So I mean, I heard you saying that once the bill comes in, it gets the power of statute, the act, and then would it scuttle that voluntary thing out of it? I think what we mediators have been looking at is the positive side. Like we're taking horse to the water and we are saying, okay, try it out, test it out. So it's a mandatory mediation, but it's not mandatory settlement. So we just so from that perspective, maybe it will for sure help in getting legitimacy. It will help in getting recognition. It will help in in making people more aware of it, and getting license. That for sure will be the positive impact. Now let me just also hear from you in terms of what kind of cases you think are eligible for mediation. Because what happens in mediation bill, if you look at, there's a schedule 4, which is a whole long list which says these kind of cases or disputes should not be eligible for mediation. And again, I'm saying as a mediator, I've started becoming uncomfortable that why, unless until we're talking about fraud, criminal intent or something like that. I think if we pass through the muster of mediation, if it fails, it fails, but we probably would have taken a step. So you being a cyber lawyer and AI technology, you kind of get to see it every day, day in, day out. Do you see it makes sense for any kind of restrictions on that type of disputes, unless until they are great?
I think we should leave it fairly open. The mediation bill definitely excludes criminal matters from the purview, or third-party rights, whether those are involved, or things which deal with, say, minors or persons of unsigned mind or something. So those are those excluded categories. But I feel by and large we should encourage more of mediation, whether it's even if it's family disputes or otherwise. A lot of times it has helped in India. it's different from definitely the Singapore Convention, which has different exclusion categories where family, inheritance, employability, those questions are, or those subject matters are outside the purview of the convention. But in the domestic context, at least in the mediation bill, it's something that we should explore these areas, and we should leave it open-ended, barring, yes, of course, certain categories like criminal, cases, which cannot be definitely a part of this because it's a state matter. So that's something that I'm of a view that the more we encourage mediation, the lesser there will be, conflicts, and quicker resolution always is better for the different kind of conflicts will be reduced. It is definitely going to be, beneficial even from the court point of view, because I know you may or differ from me on this point, but there is a huge backlog of cases, and that should not be the impetus to actually promote mediation. But I'm seriously of the view that, having seen and practiced law for like 2 decades now, and understand the nuances of both litigation and arbitration, and I think mediation is the most promising solution for the time being, because it is something that a litigant, prospective litigant, can be really happy about, that in a short frame of say 2 or 3 sittings, if he's able to get a resolution and an amicable settlement where he's able to even, to a great extent, safeguard, or rather secure his relationship with the opposite side. If that is also something that can be maintained, then that is a win-win situation for him, rather than going in for a litigation, which we don't know how long it will take to resolve.
Absolutely. No, the point well taken. And yes, you brought it up that, as a passionate mediator, I would actually want to accept any reason
Yes.
which can help promote mediation, and at least let people understand that, there is a possibility. Let that be the first port of call. And, and let that not be any kind of a stigma or a failure in case it doesn't work out. I think it's a very noble cause. One should get it, right now. Now, a question: lawyers as mediators, and of course the skill set required. Your take on this?
Well, lawyers can actually be very good at mediation, because having looked at the legal issues which are involved in a particular case, they're able to advise the client, and they're able to sift out, the real issues which are involved, and the mindset of the client. In a way, I think every lawyer has also got a sixth sense where he can read the mind of the client. He may say something, but there will be something else. The motives may be different when you come to making or drafting these matters. We realize there are different issues like ego. There could be family grudges. There could be even commercial disputes, a different ideology that the two adopt, whether it's a seller-buyer dispute or commercial dispute. There may be different reasons for why they want to get into a litigation. Not just in say defamation cases. There is a lot of reputation at stake, and in companies, when we deal with say data thefts or other kind of cases, they could be even resolved through court mediation, and that court and ex mediations have been successful in a lot of defamation and data theft cases that we've handled, and we've seen a huge trend towards the same. In even other kind of disputes, whether it's intellectual property related disputes or any kind of even domain name dispute challenges, and other kinds of issues, trademark related issues. And their IP data or even IT assets which are at risk, the taking back or delivery of infringing goods, those kind of issues. There are suits which are filed in the courts. There are commercial suits also which may be there. But if it is mediated, a lot of extent, the claim on damages and the injunction that their parties are seeking, they actually come to a mutual compromise, and they say, okay, we will not, say publish any more defamation content, defamatory to the opposite side. And the other party might say, okay, that's fine. If that is the case, I will reduce my claim on damages. And they agree on a compensation figure, which is fair and just according to both the parties. And they both go in for a compromise. So those kind of situations and consent decrees are also being passed. That's a very good sign. And I feel that one needs to look at, this mediation from the point of view of mindset of the client. Lawyers can be very good at trying to even if you're appearing as a counsel in a mediation, then it is different. Then you're more like you're suggesting to the client what all safeguards he needs to keep in mind while negotiation of a settlement or while the mediation happens. But from a mediator point of view, if you're a mediator, as a counsel, you have an experience. Your job there is to help the parties, facilitate the parties to reach an amicable settlement. So you can actually read the mind of the client and both sides, rather, not just for your own client, but you can actually see and evaluate much better. You could play the role much better in that respect.
Right. So one thing would be there, like, the lawyer, of course, may not be able to sit as a mediator if one of the parties is his client to avoid the conflict of interest. But otherwise, would your answer be same or similar if you're talking about not any other lawyer, but a litigant lawyer, who spends half a day in the court trying to prove a party right or wrong, right? And this entire, style of working in the approach. And then, probably in the mediation, you need to be kind of taking a back seat, let the parties speak, reduce the gap, prod them to, have a fresh perspective. Do you see it can be a challenge for someone to have a, split personality that, okay, in the morning I'll fight it out, but in the second half I'll probably, play a, second settle or something. So would the answer change, or you continue?
It's a very interesting question you put. I think, Sanjeev, I really agree that we are after all human, so when it comes to psychology, you may play the role of a lawyer who's fighting for a litigant, and you think differently. Then you're more adversarial, as we call it.
Yeah.
But the approach in mediation is very different, because there, if you're a mediator, you cannot advocate for any party.
Okay.
And you have to be neutral. You have to be independent, unbiased, and without any prejudice against or in favor of any particular party. So there you have to be just neutral, and his role there in that case is to help the parties reach a settlement. And he cannot even, in fact, sometimes I feel there are divergence of views on this, but I feel that they may help out parties resolve disputes, but they on their own sometimes cannot even suggest solutions. It is both parties to actually arrive at a settlement. And the mediator is only watching, and he's only helping and facilitating, but he cannot say, okay, do this or do that. So that's something very interesting role of a mediator.
Then, like between conciliation and mediation also, where
absolutely
more proactive versus this thing. But yes, point taken.
Yes. So here definitely there's a dilemma. So in the morning, if he's arguing cases for a client, and then he suddenly comes up and says, okay, now I'm a mediator, one has to really shift roles, and very, very important to be in the role, because otherwise you're not going to be fair to any party. So that's something which I completely agree. And I think this Mediation Council of India, which, if the bill gets enacted, will be looking after the accreditation, the training, the basic requirements for having a particular mediator. But I don't think they should be a fourfold criteria, like we've seen that they have to be registered in, say, legal aid cell, or they have to be also there as a trainee.
Right. So we'll have to wait for the rules and regulations.
Yes.
When the devil lies in detail, So we'll have
yes, but one has to give it a careful thought of what will suffice. But it cannot be overburdensome, because then we'll not be encouraging, but actually discouraging mediation, which shouldn't be the case.
Absolutely. Okay, so the last question from my side. Government being the biggest litigator, do you think mediation is going to work for the government department? You've been interacting with the government thing, but maybe slightly shorter, crispy answers so that we can, contain that.
Surely. I think government should, that's something that one would really encourage, mediation if government disputes also can be mediated, because there are lots of cases where there is commercial angle involved, and it is not something which is criminal or otherwise, and it's something purely that is a conflict between a litigant and the government, and mediation certainly can prove very useful in the same. I don't think we should exclude that category out. But we have to be very careful of what rules we pass under the mediation bill, because if it really needs any approvals from the central government for any regulations to take take effect or be issued, that can be a conflict of interest even, in certain cases. Yeah.
Sure, because any officer of the government is working in a strict hierarchy and a system, and then we have this famous three C's which have to be taken care of, right? CVC, CAG, CBI, all those things. So people have this apprehension about whether they can reach out and take some initiative. So I think yes, you are right. It should not be excluded, but government should really kind of focus on this, that whatever is amenable, the kind of dispute, because every dispute with the government primarily would have a commercial angle to it. So maybe creating a committee so that it doesn't fall on one person. Something like that should be encouraged, and probably we start slow, do a soft launch, as they say, and see how it evolves, right? Okay.
Yes, I completely agree with that approach.
Okay. So great. I think that's the time we had, and that was nice. And we thank you to have taken out time on this very important topic. And this is actually a help to our initiative where we try and put these recordings out, we interact with people, and many stakeholders they get energized. They see these recordings, they get to have answers what are otherwise troubling them. So it's an effort that you have been contributory, and thanks again for the time, where it'll help in awareness and sensitization. So we look forward to having many more sessions like this. Probably we are having roundtables and other discussions. We'll come back to you and we'll invite you again. So thank you for the time today.
Thank you. It's my pleasure. And like I said, I'm a strong advocate of mediation, and very hopeful and promising future for mediation in the country, and globally, of course, it's doing very well.
Great. Thank you. So thanks a lot.
Thank you.